Hello and welcome everybody. My name is Mitchell Zadow. I'm the Managing Principal here at Sharrock, Pitman Legal, and thank you very much for joining us this morning for our webinar on family trusts. And before we get started, we would like to acknowledge the Wurundjeri people of the Kulin Nation as the traditional owners of the land on which our office is located, and we pay our respects to their elders past, present and emerging, and we extend this respect to all First Nations communities throughout Victoria and wherever you may be logging in from. So I know many of you have attended our webinars before, so welcome back. And if it's your first time, a very special welcome to you. And we hope these webinars are a helpful resource just to bring up to speed with some must-know information, we think, on different topics, different things that we're encountering in our practice day-to-day that we think are worth sharing with you for your own knowledge. You can catch up with recordings and slides for our previous webinars on our website if you go to the resources page, and we'll have some more details about that at the end of the slides. And you'll find webinars there that our lawyers have presented on for a wide range of topics, including commercial and business law, property law, employment law, wills, litigation and disputes, and of course, wills and estates. If you don't know much about us at Sharrock Pitman Legal, we're a boutique-sized law firm with accredited specialists in commercial law, property law, workplace relations law, and wills and estates, of which Binay is one of those accredited specialists here in Victoria. So we're able to dive deep into all of these legal issues with real expertise and experience. But today we're looking at family trusts, particularly in relation to things you should be thinking about in the long term, in terms of succession and estate planning, as well as some updates on issues we've been seeing, as I said, in relation to things like lost trust deeds and some developments that are happening in the case law as well. So I'll shortly hand over to Binay Prasad, who will be taking us through today's content. Binay is a senior associate here at Sharrock Pitman Legal, and as I said, also an accredited specialist in wills and estates law. He's also a member of STEP, which is the Society for Trust and Estate Practitioners. So he's very qualified to be talking about these things with you today. Before we begin, I'll just run through a couple of housekeeping things. We are recording the session and it will be available on the website soon. So if there's anything you miss, we will share the link for that once it's uploaded. And if you have any questions along the way, feel free to type away in the Q&A function of Zoom. We'll try to get through questions as we go along, and we'll also have some time for questions at the end, time permitting. If we do run out of time, don't worry, we'll keep track of your questions and get back to you afterwards. And we'll also put our contact details up again at the end of the session too. One final thing before we begin, we are lawyers, so of course we need some fine print. Needless to say, we can only give some general comments and guidance in a session like this. Everyone's circumstances, particularly in an area like this, are very different. So it's really important to keep that in mind as you're thinking about your own situation and get some advice before doing anything, of course. And naturally, we're talking about the law as it relates here in Victoria, which is relevant when we're talking about trusts and things like that. So keep those things in mind, please, as we go along, and do get in touch anytime if you've got any queries. So we'll get started now, and I'll hand over to Binay. Thank you, Binay.
Thanks, Mitchell, and welcome everyone. Good morning, and thank you for joining us today. Before we get started, I just did note that we seem to have quite a wide variety of attendees today, which is fantastic. We seem to have some of our clients who might have a family trust or perhaps thinking about starting a family trust, some accountants, financial planners, and even some lawyers, which is really good. But because we've got such a wide variety of attendees, I'm not going to get too legal or technical, so not too much about legislation and case law, because I know that usually bores everyone except for lawyers. But just a general overview of trust law. If you have your own family trust or you have clients who have family trusts, just some useful things that you should be aware of. So we're going to just start with a bit of an introduction about what family trusts are. I know a bit basic, particularly for perhaps some of the professionals out there, but then we'll be moving on to some more in-depth stuff about succession of trust, how to plan for succession of control of a family trust, what to do if you discover that the original trust deed is lost, which actually can be a problem. We're seeing it arise more and more often, and then also some recent developments about the exercise of trustee discretion. All right, so what is a family trust? So it's not a legal term, a family trust. I mean, it's a commonly used term, but it's not a legally defined term. But generally what we're talking about is a discretionary trust. So if you go on to the next slide, Mitch, I guess perhaps I can. So this is a little diagram that I prepared. So we've got a trustee, and what's most important about a family trust is that the trustee has discretion. So the trust will have a number of beneficiaries, typically family members, extended family members, quite often charitable and religious organisations as well. And the defining characteristic of a family trust is that the trustee has discretionary powers. So the trustee can decide to which beneficiaries to apportion trust income and capital to, and when and how much. And no beneficiary has a fixed interest in the family trust. So that's quite different from perhaps, say, a unit trust where you've got beneficiary unit holders who each have a defined fixed interest in the trust. With a family trust, it's completely discretionary. And that's why it's more usual for family trust to be used within the family. It's very uncommon for business partners to have the one family trust. It's usually used within the one family unit because it's discretionary, because no beneficiary has a fixed interest. So just in terms of the usual positions in a family trust, you've got the trustee, obviously, that's essential. You can't have a trust without a trustee. So the trustee is responsible for the day-to-day management of the trust, any decisions that might arise, and most importantly, decisions about apportioning income and capital distributions and loans to beneficiaries. You can have an individual person as a trustee, but it's actually quite rare these days. It's much more common to have a company as the trustee, and the company will have directors, and it will be those directors of the company which actually make the decisions concerning the trust. And as I said before, what's important is that the powers of the trustee are discretionary. Obviously, you've got beneficiaries of the trust as well. You can't have trust without beneficiaries. And typically with a family trust, what we see is it's a very wide class of beneficiaries. There's what you can call the founders, the people who set up the family trust, their children, their grandchildren, spouses, even extended family like nieces, nephews, grandparents, etc. And then another important position within the trust is what's called an appointer. So the appointer has the power to remove and appoint the trustee. So in effect, the appointer has ultimate control over the trust, because if if they're not happy with the current trustee, they can just remove that trustee and appoint another trustee which suits them more. But the appointer isn't usually really involved in the day-to-day management of the trust. Sometimes we see that the certain important decisions of the trustee must also, the consent of the appointer is also required, such as variations of the trust deed. And also perhaps sometimes distributions of capital have to be consented to by the appointer, but generally the appointer doesn't have much involvement in the day-to-day management of the trust, but has a very powerful position in the sense that they can remove and appoint the trustee. I should have also mentioned before that family trusts, you don't need a trust deed. So a trust deed is a written document which sets out the terms of the trust. It's not essential to have a trust deed, but it's obviously recommended that you have a written document which sets out the terms of the trust and the powers of the trustee and who exactly the beneficiaries are. And in Victoria, the maximum period that a trust can exist, according to legislation, is 80 years. For the lawyers out there, there's also what's called a common law perpetuity period in Victoria, which technically sometimes a trust can exist for more than 80 years, but I'm not going to get into that because it's a bit complicated. But for all intents and purposes, in Victoria, the maximum period a trust can exist is 80 years. So why would you set up a family trust? So there's two main reasons why a person would consider setting up a family trust. Firstly, asset protection. So if you've got assets within your family trust and then you're facing any personal financial difficulties, perhaps even bankruptcy, generally the assets in the trust are protected from any actions by creditors or the bankruptcy trustee. It's not 100% effective all the time, but generally very effective, generally quite effective in protecting your assets. Or the other situation where it could be useful is if you're running a business through a family trust and the business faces litigation, then whoever's suing the business generally can only sue assets that are held within the trust and can't come after your personal assets. And the other really useful advantage from family trust is tax planning. So as I mentioned before, because there's usually a wide class of beneficiaries and the trustee has discretion as to who to apportion the income to, in effect, you can split income between a range of beneficiaries and reduce the overall tax bill.
Before we move to the next topic, Binay, there's a question that's come in. What is the difference between the appointor and the settlor?
Yeah, look, the settlor is the settlor is the person who sets up the family trust. It's a legal and largely a very kind of a historical role, but in some sense a bit irrelevant. So I'm not going to get into too much, but basically the settlor is the person who sets up the family trust usually by contributing a small amount of money to the settlement sum to set up the family trust. But after what we usually see is usually the accountant, because most family trusts are set up by the accountant. So the accountant will be the settlor, and their role is just to contribute a very nominal sum to set up the family trust, which is required by law. But after they've done that, they have no involvement whatsoever in the trust. They're not a beneficiary. They can't receive any distributions from the trust. So that's the role of a settlor. The appointer should not be the settlor. The appointer is a separate position. And the appointer is the person, as I said, who has the power to remove and appoint the trustee. So it's quite a different role to the role of a settlor. All right, now we're going to move on to trust planning for succession for your family trust staff, either upon your mental incapacity or upon your death. Now, this is a really important topic, and it's a topic that a lot of people don't fully understand the importance of. And so what's really important to know is that family assets are not your personal assets. They're assets that the owner of the assets is the trust. So when you do a will, your will only cover your personal assets, so assets in your personal name. And so when you die, your will distribute those assets in your personal name. A will doesn't apply to assets in your family trust. So you can't gift, say you own an investment property in a family trust, you can't gift that property to a particular person in your will. But what you can do and what you should do is properly plan for who will take control of the trust upon your death. So as we were talking about earlier, there's some important positions within a family trust. There's the trustee, and then there's also the appointer. So it's very important that you take steps to control who will be appointed to those positions after your death, so that you have some control over who will be operating the family trust after you've died. So in terms of planning for control of the trustee, sorry, I'm talking about death here, not mental incapacity, but I'll get onto incapacity in a minute. So if you're planning for death, if the trustee is a company, which it usually is, you can gift the shares in that company through your will. So if you're the owner of the shares in that corporate trustee, you can gift those shares to the person that you wish to control the trustee upon your death. But what's important, what we often see is that you've got to make sure there's sufficient shares in the company to put that gift into effect. So quite often what we see is that a client might, their company, which is the trustee, might have only 2 shares, but they've got 3 children. And so when they die, they want the shares to go to the 3 children. But obviously you can't give 2 shares to 3 children separately. They'd have to become joint owners of the shares, which isn't always ideal. So if that's the situation, you might want to talk to your accountant about whether the number of shares in the company can be increased, so that it can be easily divided between your children or whoever the beneficiaries are going to be. But just make sure you get proper tax advice, because we're lawyers, we don't advise on tax, and you want to make sure that by increasing the shares, you're not causing any adverse tax consequences. So that's how you give the shares in the company. And then also with the position of director within the company, you can't appoint another director in your will. So what we normally recommend is to do a company resolution before you've passed away, just saying that on my death, I wish for this person to become the director. So so by gifting the shares and by appointing the director, that's how you'll make sure that your desired person has control of the trustee after your death. Now, moving on to the appointer, this is very important as well, because as I said, appointer is arguably the most important position within a trust. You need to check the trust deed. The trust deed will set out how you nominate a successor appointer on your death. You can't always do it in your will, so it's important to read the deed first. If there are more than two appointers, so quite often husband and wife will be the two appointers. If one of them dies, then usually what happens is just the surviving appointer just continues as the sole appointer, unless it says anything different in the trust deed. And what we notice, because we review a lot of trust deeds for this purpose, what they normally say is you can nominate a successor appointer in your will, or just by completing a separate deed, which is a separate written document. And usually the default position is if you haven't made a nomination as to who the appointer will be, then on the death of the last appointer, that appointer's legal personal representative will be the appointer. So that legal personal representative means either the executor, if they have a will, or if they have no will, then the administrator of their estate, which isn't ideal because it's particularly if you don't have a will. You might not know who's actually going to be the administrator of your estate and then who will actually get control of your family trust. So it's really important to be thinking about these things whilst you're alive and making sure that the person that you wish to put in control of your family trust, that the legal paperwork's put into place to put that decision into effect.
I'd add to that, even if you had a will and you've got 3 children, for example, you might only be appointing 1 or 2 of them as executors, or even if you appoint all 3 as executors, one might not decide to act in the end, and then you'd end up with a situation of only 1 or 2 kids controlling the family trust, which wouldn't be ideal either, would it?
Yeah, and we're going to move on. I know this is perhaps a bit intellectual at this stage, but we're going to be moving into some more concrete examples where you can probably see how proper estate trust planning can really be a good thing. So now we'll just move on to incapacity. So this is another important thing. So a lot of you might know what a power of attorney is. So that, it's a document where you appoint another person to be able to act on your behalf if you lose capacity. Now, what's really important to know is that the person you appoint as power of attorney, they won't always be able to step into the positions of control in your family trust. It's really important that you get proper legal advice to make sure you plan for this situation. So again, talking about the trustee, which is usually a company, if you've made a standard, a kind of enduring power of attorney, the attorney that you've appointed, they can't step into the position of director if the director's become incapacitated. So occasionally we do see situations where, dad might have his own company and he's the director and he's lost capacity and he's appointed daughter as his power of attorney, and then she just starts signing company documents as attorney, but dad's still the director. He hasn't been removed. So that actually isn't, those decisions that the daughter's making as attorney aren't actually valid. An attorney can't make decisions on behalf of a director. But there is a proper way to do this. So an attorney can exercise the rights of a shareholder. So quite often, if you've got a company where it's a sole director and sole shareholder, and they're the same person, if the shareholder loses capacity, then their attorney can actually step into the role of shareholder and use those rights to remove the incapacitated person as a director and to appoint themselves as a director or any other appropriate person. And if that's done, then so you're actually removing the incapacitated director and appointing another director, then that's fine. And then that new director can just start making decisions on behalf of the company and the trust. And appoint is another appointed position. So an attorney under an enduring power of attorney can't just step into the role of an appointer either. So if the appointer loses capacity and their power of attorney just starts signing things on behalf of the appointer, those decisions won't be valid unless it's authorised by the trustee. And usually what we've found is that it isn't authorised by the trustee for a power of attorney to make decisions on behalf of the appointer. What the trustee will normally state is that if an appointer becomes mentally incapable, then they're automatically removed as the appointer. So you could have a situation where there's actually no appointer of the trust. But what the trustees, as we were talking about previously about planning for your death or the planning for the appointer's death, Usually the trust deed will allow a successor appointed to be nominated by a deed, which is a separate written document. So the appointer can actually nominate a successor appointed to step in when they lose capacity. So that's a separate document from a power of attorney. It's a separate deed where the appointer says, I want this person to act as appointer if I lose mental capacity. So it's really important that that document's in place. So we're going to move on to a case study here, and this is a fictional case study, but I just thought it might explain better what I've just been talking about. So Jane is single. She's got 2 adult children, Mark and Sarah. She has her own family trust called the Turner Family Trust. And the trust owns a number of investment properties, and Sarah, her daughter, lives in one of those properties in Glen Waverley. So I'm going to first discuss, actually, no, sorry. Let's just explain the trust in a bit more detail. So the trust deed for the Turner Family Trust. So the trustee is Turner Proprietary Limited, a company. Jane is the sole director and shareholder of the company. And Jane's also the appointer. So the appointer has the power to remove and appoint a trustee. And the trust deed also says that a successor appointer can be nominated by deed or by will. And if no successor appointer is nominated, then on the death of the appointer, their legal personal representative becomes the appointer. So as I said, that's either the executor of their will, or if there's no will, it's the administrator appointed by the court. And the beneficiaries are just the standard beneficiaries. So Jane, any partner that she might have, her children, partners of children, grandchildren, etc. So next slide, thanks. So first I'm going to outline the wrong way for Jane to do things. So Jane completes a DIY will kit she bought from the post office. She appoints Mark as the executor of a will. The Glen Waverley property, which bear in mind is actually owned by the trust, is gifted to Sarah in the will. And the rest of the estate is gifted equally between Mark and Sarah. So why is this the wrong thing to do? We'll find out. Let's just go on to the next slide. So Jane dies. The gift of the Glen Waverley property to Sarah fails because it's owned by the trust, so Jane can't gift it through her will. Mark, as the executor of the will, appoints himself as the director of the trustee, Turner Proprietary Limited, which he's entitled to do as the executor. And Mark also becomes the appointer of the trust in accordance with the trust deed, as it says that if there's no nomination, then the executor becomes the appointer on death. So effectively, Mark now controls the Turner Family Trust, even though it was probably Jane's intention that her children would benefit equally. If you look at her will, that's not actually what's happened in effect. What she's done in effect is put Mark in complete control of the Turner Family Trust. So now Mark decides to distribute the trust properties to himself because he's a beneficiary of the trust, including the Glen Waverley property, and he orders Sarah to vacate. And then Mark proceeds to wind up the trust. So Sarah's only entitled in accordance with the will to 50% of the assets held in Jane's personal name, if there are any. She's not entitled to 50% of the assets held through the trust. Sarah might have some legal recourse against Mark for breach of trustee duties, which I'll be talking about later in this webinar. But it will be very difficult for her, it will be stressful, expensive, and the outcome would be uncertain. So Jane definitely didn't do her children any favor, or didn't do Sarah any favors by doing her own will. So now I'll move on to what, if Jane came and saw us, perhaps what we would recommend is the right way to plan for succession of the trust. So she sees an estate planning lawyer. The lawyer advises Jane that she cannot gift the Glen Waverley property in her will as the property is owned through the trust. So Jane, because she really wants Sarah to receive the property, she decides to gift Sarah the property whilst Jane's still alive and in control of the trust. The transfer might incur stamp duty. Although there might be an exemption because Sarah is a beneficiary of the trust, and there'd probably be also a CGT liability. However, if it gives Jane peace of mind that the property will be going to Sarah, then Jane's happy to wear those extra costs. Next slide, please, make sure. And then Jane makes a will. She appoints Mark and Sarah joint executors. The shares in Turner Proprietary Limited are gifted equally to Mark and Sarah. The remainder of the estate, which is actually only her personal assets, not the trust assets, are gifted equally between Mark and Sarah. In relation to the trust, Jane executes the deed of appointment. where she appoints Mark and Sarah jointly as the appointors on Jane's incapacity or death. So now what happens if Jane dies? Mark and Sarah, as the executors, jointly appoint themselves as directors of Turner Proprietary Limited. Mark and Sarah are appointed jointly as the appointers of the Turner Family Trust in accordance with the deed of appointment. And so Mark and Sarah jointly control the trust, and any decisions regarding the trust have to be made by them jointly. So, sorry, I think that was a bit of a mistake in the slide. This is a new topic, actually, moving on from Jane's situation. So this is also an interesting point to make, is that quite often you've got your own family trust, you might have minor children who obviously are too young to be able to take control of the death if you and your partner or spouse were to both suddenly die in an accident. And this is a really important thing to consider, and a lot of clients quite often find this quite surprising, is that because the trust is discretionary, you can't force the successor trustee, the person who will become in control of the trust on your death, you can't force them to operate the trust for the benefit of your minor children. So quite often the person that you want to put in charge of the trust, so perhaps a sibling, will also actually be a beneficiary of the trust. And because the trust is discretionary, there's a risk that the new controller of the trust might actually start distributing assets and income to themselves rather than for the benefit of your children. So it's really important that you have a lot of trust in the person that you wish to appoint to become in control of the trust if you and your spouse or partner were to pass away and you've got minor children. What you can do is to sign a memorandum of wishes. So this is a statement of wishes where you state how you wish for the trust to be operated if you both were to pass away, which would obviously be just for the equal benefit of your minor children. It's not binding because it's a discretionary trust. You can't execute any documents that would bind the future trustee, but it can be taken into consideration by the successor trustee, and it is at least a statement or a document of your wishes as to how you expect the trust to be operated after your death. So that's a very important thing to consider. All right, we're going to be moving on to the next topic, which is lost trustees. Before that, did we have any questions, Mitch? Or... No. All right, so this is becoming a really hot topic, actually. The reason, well, look, let's sorry, I'll just get through this slide and then I'll talk about that in a bit more detail. So the original signed trust deed is an essential trust document. A lot of people don't understand the importance of the original wet signed trust deed. It validates all the decisions and distributions which are made by the trustees. So the location of the original trust deed should always be known. A copy of the original might not always be sufficient. And we'll explain that further in the next slide. So if you discover that if the trust deed has become lost, this might lead to a few different issues. Firstly, banks are more commonly now requiring a certified copy or to cite the original of the trust deed before they'll authorise finance. And I think the reason for this is the federal government's brought in these new know your customer requirements for banks to prevent against money laundering and terrorism. And now it's quite common. I mean, in the past, I don't think banks usually wanted to see a certified copy or the original, but now they do. And that can be a real problem if the trust has perhaps purchased a property, assuming that it would get financed and the settlement date's coming up, and now all of a sudden the bank's requiring the original or a certified copy of the trust deed and it can't be found. Or perhaps what we've been seeing in the courts is a dispute arises between family members over trusts or how the trust is being operated. And then the family member that's challenging the trust asks to see the trust deed, and then it's discovered that it's actually lost. And then the family member says, well, hang on, how do you know these distributions that you've been making are actually valid? And I'm going to challenge these distributions in court. And it can also... if the trust deed can't be found, and particularly if a copy can't be found either, then how does the trustee know that the distributions that the trustee is making to, from a tax planning perspective, how does the trustee know that those distributions are actually valid? And if the ATO or the state revenue officer were to investigate could the trustee prove that they actually had the power to make those distributions? So you've lost the trust deed, but you have a copy. Is that okay? So a copy is not a substitute for the original. If you're 100% satisfied that the copy is identical to the original signed trust deed, then a practical decision might be made just to rely on the copy as evidence of the contents of the original trust deed. However, there are risks. As we were talking about earlier, trustee decisions could be challenged or investigated by the relevant tax authorities, and banks will usually not accept just a copy. They'd want a certified copy or to cite the original. So a possible solution, if the trust deed has been lost and you've got a bank asking to see the original or a certified copy, a possible solution is to do what's called a deed of confirmation. So in effect, it's a new deed to confirm the original terms of the trust deed. So a new deed that the parties sign. And so in effect, you've got a new original trust deed, but it's actually just confirming what you believe to be the contents of the original trust deed. We would say you should only consider this option if there's absolute certainty regarding the terms of the original trust and any later deeds of any later variations to the trust. So, for example, you found an exact copy, but you should always get specialist advice. It's also a good idea to get the consent of beneficiaries if you're going to be executing a deed of confirmation, so that will avoid later disputes with beneficiaries. And a deed of confirmation might still not be accepted by a bank. We've had at least one client recently who tried to convince the bank to accept a deed of confirmation, but they wouldn't. And the deed of confirmation could still be challenged by family members if there's a dispute. If there's any uncertainty about the terms of the original trust deed, then we wouldn't recommend doing a deed of confirmation, because what you could unintentionally do is actually cause what's called a trust resettlement. So a trust resettlement, in effect, it's a complex legal topic, but in effect, what it means is the laws regarded you as actually creating a new trust, and then all the assets held in the original trust will be deemed to have been transferred to the new trust, and then that can trigger capital gains tax and stamp duty consequences. So, yeah, we definitely wouldn't recommend doing a deed of confirmation if there's any uncertainty about the original terms of the trust. But really what the gold standard solution to do is, if you've lost the trust deed, is to make an application to court to confirm the terms of the trust. It's the most legitimate option, but it's also can be quite expensive. It's an application to the Supreme Court in Victoria. The court's usually willing to assist. The court doesn't like to see trusts fail, but at the same time, the court's going to need sufficient evidence of the original terms of the trust. The court's not just going to act as a rubber stamp and say, oh yeah, you've lost the trust deed. Oh, that's fine. We'll just create a new trust deed for you. No, the court will want some evidence as to what were the terms of the original trust, so that the court can actually confirm those terms in a court order. So in terms of some previous cases, which are published cases, they're not necessarily cases our firm assisted with, but where the court agreed to make an order to confirm the original terms of the trust, some situations where the original trust deed couldn't be found and a copy couldn't be found, but they found an unsigned copy and the court accepted that as sufficient evidence, along with some other evidence from the accountant about distributions and things like that. Another situation, neither original nor a copy could be found. So the solicitor who drafted the original trust deed provided evidence to the court about what their standard trust deed precedent was, and the court accepted that most likely the trust deed for this trust you used the same precedent that solicitor always used, so that was sufficient. And then there was a recent case of Mantovani and Vanto. This is a Victorian case from a couple of years ago where they couldn't find the trust deed. All they had was a copy of the schedule to the trust deed saying who the appointer and the trustee and the beneficiaries were, but there was the rest of the trust deed just couldn't be found at all, not even a copy. So that was submitted to the court, as well as some past financial statements from the trust showing, how the trust was operated and who received distributions, and the court, from that evidence, was able to determine what the original terms of the trust deed were and was able to make the relative order, or the required order. So if the court confirms the terms of the trust by court order, then this usually will be accepted by banks and will provide the best protection against future disputes or investigations by the tax authorities. So some key takeaways regarding lost trust deeds. So always check, do you or your client, do you know where the original signed trust deed is? As I said, a copy doesn't always cut it. For professionals, if you're giving advice about the trust or about trust distributions, just make sure you see an original or a certified copy of the original trust deed. Don't assume that the trust is a standard trust deed, and don't assume that the beneficiaries who are receiving trust distributions are authorised under the trust deed. If the original trust deed has been lost, then we recommend you seek legal advice early, and don't wait until you're asked to show the trust deed to a bank or authority, or there's some family dispute. All right. This is the next topic. Did we have any questions, Mitchell?
No, not at this stage. Thanks.
All right, this is a really important topic to know as well. There's been some quite significant court cases recently about the powers of a trustee and what discretion a trustee has when allocating income and capital from a trust, which has always been the law, but it just seems that just recently there's been a number of recent decisions which have really confirmed the court's view, and it's actually really surprised a lot of people who run their own family trusts or advise people who operate family trusts. So with your classic family discretionary trust, the trustee has discretion to distribute or loan income and capital to a wide class of beneficiaries. So commonly the person who controls the trust, usually the directors of the corporate trustee, will believe that they've got free rein over how the trust assets are allocated between beneficiaries, and they'll often treat the trust assets as their own. But there are some constraints on the exercise of trustee discretion, which we'll get into. Sorry, yeah, thanks, Mitchell. So the courts have stated that trustees have certain duties when they're exercising their discretion. So they have to act in good faith, reasonably and responsibly and reasonably. The decisions have to be made upon real and genuine consideration, and the decisions should not be made arbitrarily, capriciously, or mischievously. So just some recent Supreme Court cases here in Victoria about how the courts have viewed this matter. So there was a case a couple of years ago called Trani and Trani. So just the facts on this one. So Mr. and Mrs. Trani had their family trust, and there was a trustee, Latina Investments Proprietary Limited. They passed control of the trust to their 3 children during their lifetime. The trust, I think, owned a number of business interests in investment properties and things. So that they passed control to their 3 children, Luciano, Marco, and Patrizia. So the 3 children were appointers. The 3 children were directors of Latina Investments, but Luciano was the sole shareholder of Latina Investments. I think he was also, for some reason, he was always the sole shareholder, even from the creation of the trust, even when the parents were in control. And that was really the undoing, Luciano being the sole shareholder, which I'll get into. So Luciano, the 2 brothers, Luciano and Marco, ganged up on Patrizia, their sister. They removed her as a director of Latina Investments. That was due to Luciano's powers as sole shareholder. And then now Luciano and Marco control the trust. Even though Patrizia was an appointor, she couldn't remove the trustee because the 3 children were appointers. So they have to make decisions jointly. So if 2 of them, if Patrizia wanted to remove the trustee, but the other 2 brothers said no, well then the trustee isn't removed. So in effect, because Luciano and Marco had control of Latina Investments, they effectively controlled the trust. And then they decided to distribute all trust assets between themselves. They excluded Patrizia, and then they wound up the trust. So Patrizia challenged the trust distributions in the Supreme Court, and the court agreed with Patrizia and found that Luciano and Marco had acted in bad faith. Their decision to distribute all the trust assets to themselves was motivated by animosity towards Petuzia rather than being made on real and genuine consideration of the needs of beneficiaries. And in fact, the court ordered that Petuzia receive 1/3 of the proceeds from the sale of the trust asset. So, and most people would perhaps agree with that decision. I mean, Marco and Luciano were really doing the wrong thing by their sister, and perhaps it was a fair outcome in the end. But moving on to this next decision, this is about the Owies family trust. This has actually really surprised a lot of people because it's really put some limits on how trustees can control a family trust. So there was the Owies family trust established in 1970 by John and Eva Owies. So John and Eva controlled the trust. They were the appointors and the directors of the corporate trustee. They had 3 adult children, Michael, Paul, and Deborah. So John and Eva favoured Michael. Their relationship with Paul and Deborah was strained, and Deborah was in a poor financial position as well. The schedule of the trust deed, so that should say trust deed, listed the 3 children as the primary beneficiaries of the trust. And perhaps unusually, John and Eva were not primary beneficiaries. It wasn't clear why they weren't listed as primary beneficiaries, but they weren't. They were just included in that general class of beneficiaries. So the trustee, which John and Eva controlled, made a number of decisions about distributions of trust income between 2011 to 2018. So decided that 40% would go to John, the father, 40% to Michael, the son, and 20% to Eva. So the other 2, Paul and Deborah, didn't get anything. And then in 2019, 100% of the income, so about $1 million, it was quite a wealthy trust, was distributed to John. Now, John was 96 at the time, and he was living in aged care. So Paul and Deborah challenged the fact that they hadn't received any distributions over the last 7 or 8 years. And the court agreed with them. The court found that the trustee's decision to distribute income just to John, Eva, and the other son, Michael, I think his name was not made in good faith because the trustee did not make proper inquiries regarding the needs of Paul and Deborah. I mean, there were a number of complex reasons, so I'm summarising here, but the trustee did not make proper inquiries regarding the needs of Paul and Deborah, and also John being the father, was 96, was not in need of the $1 million given his age and that he was living in aged care, so you'd assume he'd have very minimal expenses. So the distributions of income that had previously been made to John, Eva, and the other son, Michael, were set aside. And just as a further kick in the guts, the trustee was removed and an independent trustee was appointed as the court found that the trustee had acted in bad faith. So the court placed great importance on the fact that 3 children were listed as primary beneficiaries, but the trustee was only favouring one of those children. So, just because the court decided this particular case in this particular way, it doesn't mean that all cases will decide in this way. It will, like I said, the court placed a lot of importance that the 3 children were listed as equal primary beneficiaries, which often isn't the case with most trustees that we see. So some key takeaways just from those recent cases. If you operate your own family trust, don't assume you've got complete control over the trust assets and income. Courts can intervene if satisfied that the trustee is not acting in good faith. And when establishing a family trust, consider not listing the children as primary beneficiaries. Quite often when you set up a trust, the children are minors, so you're not really aware how they might turn out. But perhaps to play it safe, consider not listing the children as primary beneficiaries. If the parents are if you're estranged from a particular child, consider excluding that child as a beneficiary, but this should be done at the commencement of the trust. If you've already got a trust and then you've had a falling out with a child and then you take steps to try and remove that child as a trustee, firstly, that decision in itself might be challenged as being not made in good faith. And more significantly, it might actually potentially cause a resettlement of the trust where you're creating a new trust. And then that creates that could create a lot of tax consequences. So, just something to keep in mind. Before making distributions of income or capital, make inquiries with the beneficiaries as to whether they're in financial need, and always, if in doubt, get specialist legal advice. All right. How are we going for time, Mitchell? Still good? Yeah. So this is just the last topic I wanted to cover. This is a matter that our firm actually assisted with recently. It was actually a trust which ultimately had no beneficiaries, and we had to figure out what to do. So Sophia, not her real name, just to protect client confidentiality, she operated a family trust, which is set up by her lawyer. Just disclaimer, it wasn't us, because it was a really terribly worded trust deed, but it was set up by her lawyer in 1983. There was a company as a trustee, and Sophia was the sole director and shareholder of that company. So the trustee, the beneficiaries, and this is very unusual. I've never seen anything like this before. But anyway, the beneficiaries were quite restrictive. So it was either Sophia, her children, or any spouse of her children. The trust owned a block of units in Brunswick worth about $3 million. And I think Sophia didn't properly understand this trust and that it was a separate legal entity. And I think she basically regarded the trust as her own assets and the assets in the trust as her own assets as well. But anyway, Sophia died in 2017. She actually had no partner, husband, partner, or children. And she'd actually made a DIY will, which I think she'd got from the post office, which divided her substantial estate between a number of friends. So there was no mention of the family trust in the DIY will. The executor of Sophia's estate, who was one of her friends, sought our assistance. He asked, look, can the trust assets be just distributed to the beneficiaries in Sophia's will? And we advised, no, you can't do that. And why? Because the estate or the beneficiaries of the in Sophia's will were not beneficiaries under the trust deed. So you can only distribute trust assets to the stated beneficiaries in the trust deed. And the problem was that there were no beneficiaries because Sophia had died, and the only other beneficiaries were children or spouses of her children, but she had no children. So there was no one effectively to be able to distribute the trust assets to. And as a further problem, the executor had gone to his accountant, and his accountant had actually assisted him to execute a deed of vesting for the trust. So basically what that means is that the accountant had created some paperwork to end the trust and also to deregister the trustee as a company. So this was a problem. Firstly, you can't vest a trust if it still holds assets. And secondly, because the company, the trustee, had been deregistered, there was effectively no trustee of the trust, so the trust was effectively paralysed, and no one could really do anything to progress the trust. So how did we assist the executor? Firstly, we made an application to ASIC to have the company reinstated, which isn't a simple process. ASIC needs a proper explanation as to what happened and why was this company deregistered and why are you seeking to reinstate it. But the application ultimately was granted, which is great. Now we've got a trustee again. And the second step was to assist the trustee, the company, the directors of the company, who was also the executor, to apply to the Supreme Court for permission to vary the trust deed to allow the trust assets to be distributed to the beneficiaries of Sophia's estate. So the court required evidence that this would have likely have been Sophia's intentions, and the court granted our application. And so the last step was just to distribute the trust assets. The Brunswick property had been sold by this point, and the cash was held in the trust. So the step 3 was to distribute the assets to the beneficiaries of Sophia's estate in accordance with the will after payment of capital gains tax, etc. So a good outcome in the end, but caused significant delay. It was about 2 years while we sorted all this out with the application to the court and getting the company reinstated. And also there were significant legal costs which could have gone to the beneficiaries, but instead went to lawyers. So what are some takeaways from this case? Take care when you're setting up a family trust. You need to properly consider who should be the beneficiaries and plan for all possible situations. Do not operate in a trust which is not authorised by the trust deed. Seek specialist legal advice. An application to court might be required to authorise what you wish to do. And if you operate your own family trust, then we recommend don't make a DIY will. It's complicated, and we would recommend that you see an estate planning lawyer.
Thanks, Binay. That sort of brings us to the substantive part of the webinar, everybody. We do have some time for a couple final questions. So feel free to put those into the Q&A box if you'd like. I can see somebody's raised your hand, but best if you can put it into the question and answer function if possible, or contact us later if you'd prefer. Just while we're seeing if any questions come through, one of the bulletins that we send out regularly is our Wills and Estates Bulletin. So if you're not already receiving that and you would like to, please feel free to get in touch with Anna from our office. Her email address is there on the screen, or you can get in touch with me or Binay as well, and we'll make sure you get those. We're always putting together updates on things that are happening. And as you can see from some of the material today, courts are often making decisions on these things in sometimes surprising ways, and so we could never assume, or should never assume, that things are set in stone. Thank you, Craig, for your comment there. And we do have a question from Kwan. In a will, if an asset is passed to a family trust, can the trustee assign the asset to a wholly owned company in the family trust?
I think I understand Quan's question. So a will, you can gift an asset to a family trust in a will. So if you hold an asset in your personal name and you want it to be gifted to a family trust on your death, then that's possible. And then once it's in the trust, can the trustee assign the asset to a company? If the company falls within the class of beneficiaries, then yes, the trustee can distribute the asset to that company. Just be aware there could be stamp duty and capital gains tax. Sorry, if you're talking about real estate, there could be stamp duty consequences and also perhaps capital gains tax consequences as well.
Yeah. And the follow-up question kind of about, would there be CGT if it was passed
to
a wholly owned company?
The general position is if it's in your name and then you gift it to a family trust on your death, that the transfer from your name to the family trust, that doesn't trigger CGT because it's in accordance with the will. But then once it's in the trust, if it's then transferred to a beneficiary of the trust, then there may be CGT consequences.
Yeah. Our advice would be always get some legal and tax advice before moving any assets around. Yep.
Sorry, did you want to deal with some other questions?
Thanks everybody. Good questions throughout the session. In a similar vein to the updates, we do have articles and the previous webinars in this area on our website. And if you follow us on social media, you'll see when we have articles being published from time to time. There is one final question. We just have time. What happens if an asset is passed directly to a wholly owned company? I think you're asking about an asset being passed via the person's will to a company. That would be okay. You can have the company could be a beneficiary in the will of a particular asset. It would be very important, though, to make sure the asset is carefully identified in the will, so that it's clear that that particular asset is to be passed to the company. And you might also want to make sure that the asset actually does belong to the person making the will, and that it does fall within their personal estate as well. So follow us on there for updates. We do have a couple of webinars coming up, so we will have another Wills and Estates themed webinar later in the year if you'd like to save the date and pencil it in. But our next webinar will be with me and my colleague Samuel, one of our commercial and employment lawyers, on the PPSR. We're seeing a lot of talk and queries coming in about the Personal Property Securities Register, and how to protect your interests by registering secured interest on there, but also what to do if third parties have security over your companies or assets or your personal assets. So we'll be sending some more details around soon about that webinar. And finally, if you would forgive me a bit of a plug, if you're interested in some information about how a systems approach can help you develop your business or organization to achieve greater success, I'd encourage you to have a look at fightingforenterprisesuccess.com and the book by David Sharrock. It's available in hard copy and an ebook. It's full of lots of wisdom, guidance, and reflections from David, as well as nearly 70 self-assessment tools, templates, and samples that we've developed in our own practice that are provided just by way of a bit of suggestion. There might be some ideas that can be sparked from all of that. So do take a look at that if that's of interest. And that brings us to the end. So thank you very much, Binay, and thank you everybody for joining. We'll make the recording available shortly once it's uploaded to the website. And if you do have any questions on any of these things or any other wills and estates related issues, trust issues, or anything else, please do feel free to get in touch. In the meantime, we wish you all the best and hope you have a nice day. Thank you.